Stratego Arcanus. Secrets revealed.
"21 years of documented harm, darling. 8 jurisdictions, wrongful detention, because apparently we're doing medieval dungeon cosplay now. 3 major breaches, 260,000 sealed records exposed, chef's kiss, exquisite negligence." According to the North Carolina Assembly, Federal Judge William L. Osteen Jr. found Tyler's pattern makes harm foreseeable. 2 documented SEC filing contradictions, same-day lies, and not even good lies, sweetie. 4 potential securities violations, substantial penalties available. So let's talk about accountability. Criminal prosecutions against Tyler Technologies, 0. Criminal prosecutions against executives, 0. SEC enforcement actions, 0. Federal Trade Commission investigations, 0. State Attorney General multi-state enforcement actions, 0. 21 years of documented harm. Federal court findings, 4 potential federal securities violations, 0 federal enforcement. The question isn't, how did this happen? The question is, who decided to let it happen? And were they drunk? Because this isn't an accident, honey. This is a regulatory system working exactly as designed to protect corporations, not citizens. Shocking. Groundbreaking. Who could have possibly predicted this? How infrastructure negligence escapes accountability. 3 reasons. All structural, all by design, and all completely preventable, but here we are. Reason 1. Distributed harm. Or death by 1,000 cuts, but make it legal. Each wrongful detention happens in a different county. Marion County, Indiana. Alameda County, California. Shelby County, Tennessee, Lubbock County, Texas. Each sealed record exposure affects individuals scattered across 30 jurisdictions. No single catastrophic event, no plane crash, no building collapse, no mass poisoning focuses federal attention. The harm is real. The harm is devastating. But the harm is dispersed. Oh, how convenient. So, one man in Indiana loses 47 days. Local story, page 6, below the horoscopes. 3 people in California wrongfully detained. County problem, settled quietly, swept under a very expensive rug. Hundreds in Tennessee, class action, years of litigation, lawyers getting beach houses while victims get, well, we'll get to that. Each incident looks isolated. Each victim fights alone. And that's exactly how Tyler Technologies designed it. Not through malice. Oh no, never malice. Through market structure. So much classier. County by county deployments. Jurisdiction by jurisdiction contracts. Which means it's invisible by design. Genius. Diabolical genius. Still criminal, but genius. Reason 2. Captured market. Or hostage situation, but make it corporate. Governments cannot switch vendors with catastrophic cost. $50 to $100 million per jurisdiction. 3 to 5 years migration time. No viable alternatives for critical functions. Tyler Technologies knows this. According to analysts, they've completed 26 competitor acquisitions since 2010, each one eliminating an exit option. Their leverage is absolute. The implicit message to every government client? Sue us if you want. Investigate us if you must. Regulate us if you can. But you still need our software tomorrow, and the day after, and the day after that. Because there is nowhere else to go, sweetie. That's not a business relationship, darling. That's hostage taking. And it works.
Because regulators know if they push too hard, if they demand too much, if they actually hold Tyler accountable, court systems might collapse, and nobody wants to be responsible for that. Tyler operates in the gap between too important to fail and too distributed to prosecute. That gap is their business model. Chef's kiss. Diabolical. Still going to hell, but chef's kiss. Reason 3. Pattern obscuration.
Until someone reconstructed the complete timeline. Until forensic investigators analyzed tens of thousands of source documents. Until temporal intelligence revealed not isolated incidents, but systematic negligence. The pattern was invisible. Dismissive, mocking corporate speak throughout, like reading from the world's worst press release. Each incident was labeled isolated technical issue, local configuration error, implementation challenge, unfortunate software defect. But when you map them, when you see Marion County 2014 next to Alameda County 2016, when you see the same failure mode repeating across years, when you see Tyler's documented knowledge of the problem, and then watch them deploy to North Carolina in 2023, the isolated incidents become a pattern. The local errors become systematic design. The unfortunate defects become foreseeable harm. But pattern recognition requires someone doing the work, collecting the documents, verifying the dates, mapping the jurisdictions, connecting the failures. And for 21 years, no regulator bothered. Not the SEC, not the FTC, not state AGs, not DHS. Shocking. Truly shocking. Because distributed harm across jurisdictions falls into regulatory dead zones, and those dead zones? Those aren't bugs, honey. Those are features, by design, always by design. The only accountability, victims. Or do-it-yourself justice, because apparently that's legal now. The only accountability Tyler Technologies has faced, the only consequence for 21 years of negligence comes from victims, not from the SEC, not from the FTC, not from state regulators. From people who had to hire their own lawyers, from people who had to band together in class actions, from people who had to spend years in litigation, from people who shouldn't have to do the government's job. Let's talk about what Tyler Technologies considers accountability. The Shelby County settlement, or 16 cents on the dollar and the audacity. Shelby County, Tennessee. 5 years of systematic over-detention. 417 documented victims according to class action claims. Federal class action settlement, $4.9 million. Tyler Technologies contribution, $816,668. According to KTTZ radio reporting, Tyler paid 16% of the total settlement. For software they designed, for software they installed, for software they maintained, for software they charged millions to operate. 16%. Shelby County taxpayers, the people whose county government hired Tyler to help them, paid the other 84%. So the victims got compensated partially by themselves, their own tax dollars. While Tyler Technologies, according to the settlement website, admitted no wrongdoing. Let me translate that for you. Tyler Technologies paid 16 cents on the dollar for years of wrongful detention, stuck taxpayers with the rest of the bill, and walked away clean. The audacity, the caucasity, the sheer nerve. The Casey settlement. Casey versus Tyler Technologies. The March 2024 Lockbit breach class action. Preliminary settlement approved January 2025, according to classaction.org. Per victim compensation, up to $3,500. Credit monitoring, 3 years. How generous. Tyler's admission of wrongdoing, none. $3,500. for having your social security number, your driver's license, your date of birth, your financial data leaked to the dark web by a company that certified vigilant security 30 days before the breach. $3,500. That's what Tyler Technologies calculated your identity is worth. Less than a used Honda Civic. The theatrical consideration, a bad used Honda Civic, like high mileage, needs transmission work. But here's the truly insulting part. That $3,500 isn't even coming from Tyler's profits. It's coming from their insurance, which means Tyler doesn't even feel it. The premiums go up slightly, the shareholders barely notice, and Tyler keeps operating exactly as they always have. Because that's not accountability, sweetie. That's the cost of doing business. And business apparently is booming. What has changed? Or, plot twist, the receipts are now public. But something has changed. The timeline has been reconstructed. The pattern has been proven. And something fundamental has shifted. The evidence is public. The violations are recent. The enforcement mechanisms exist. The question is, who will use them? 3 paths to accountability. Or choose your own adventure, prosecution edition. Path 1, multi-state attorney general coordination. Or strengthen numbers because Tyler can't settle with everyone at 16%. Texas, Marion County wrongful detention, documented since 2014. California, Alameda County, 260,000 exposed sealed records, 322,000 attorney discipline records accessible. Oopsie. North Carolina, statewide deployment failure, 573 alleged defects, ongoing federal litigation. Still going, still a disaster. Each state has documented victims. Each state has independent enforcement authority. Each state has political incentive. Together, they have leverage. Because Tyler Technologies can settle with one state. They've done it before. Shelby County, 16% contribution, stunning generosity. But Tyler cannot settle with 5 states simultaneously without admitting the pattern. And once they admit the pattern in one state, every other case becomes easier to prove. Multi-state AG coordination isn't theoretical, honey. It's tactical. The evidence packages are ready. The jurisdictions are identified. The victims are prepared to testify. Combined leverage? Substantial. So the question for state attorneys general is simple. Do you have the political courage to coordinate? Or will you let Tyler settle with you one at a time, at 16 cents on the dollar, while your constituents pay the rest? Choose wisely, darlings. Path 2, SEC whistleblower submission. Or put your money where your regulatory mouth is. The SEC whistleblower program rewards individuals who provide original information leading to successful enforcement actions with penalties exceeding $1 million. Award, 10 to 30% of monetary sanctions. Not bad. Not bad at all. Tyler Technologies' potential exposure across 4 violations. Tens of millions in fines, disgorgement, penalties. The evidence is documented. September 2020 same-day contradiction, public records. February 2024 alleged false 10K claims, certified filing. March 2024 alleged missing 8K, violation by omission. The submission framework exists. The violations are recent, within statute of limitations. Now we see if the SEC acts, or if they continue their proud tradition of regulatory capture and selective enforcement. Because the SEC has a choice. Enforce the law, or prove once again that securities fraud only matters when poor people do it. We're waiting. The popcorn is ready. Path 3, congressional oversight hearings. Or give these victims a microphone and watch what happens. 120 million Americans depend on Tyler Technologies for their justice system infrastructure. That makes it a federal concern. House Judiciary Committee, Senate, Homeland Security. Oversight Authority? Clear. The victims are ready to testify. Marion County, Alameda, Shelby, North Carolina. 47 days wrongfully detained. 260,000 exposed sealed records. Rape survivors, domestic violence victims, juvenile offenders. Their stories exist. Their documentation is verified. Their testimony would be devastating. The public deserves to hear them. Not filtered through settlements with non-disclosure agreements, not buried in county-level litigation. On the record. Under oath. Nationally televised. So the question for Congress is, do you want to be the committee that gave these victims a voice? Or do you want to be the committee that looked the other way while a government contractor treated American citizens like bugs in their code? Public accountability. Overdue. Severely overdue. Like library fines from 2003 overdue. The pattern is documented. 21 years across 8 states. 3 ransomware breaches with documented response failures. 260,000 sealed records exposed. Federal court finding, harm foreseeable. The violations are recent. 2020 8K contradiction within statute of limitations. 2024 alleged 10K false claims within statute of limitations. 2024 alleged missing 8K within statute of limitations. 21 years, 8 states, 3 breaches, 0 accountability. The enforcement mechanisms exist. The evidence is ready. The victims are waiting. What's missing isn't evidence, sweetie. What's missing is will, and courage, and integrity, but mostly will. The choice. Or the ball is in your court, pun intended. Prosecutorial, building to climax like the finale of a courtroom drama. Will the SEC act? Does America's securities regulator have the institutional courage to investigate documented allegations against a $2 billion public company? Or will they continue pretending that securities fraud is only prosecutable when committed by individuals who can't afford defense attorneys? We already know the answer, but surprise us. Will the attorneys generals coordinate? Do state prosecutors have the political spine to cross jurisdictional lines to confront a monopolist who has allegedly harmed people in their states? Or will they continue accepting 16-cent settlements and declaring victory? Confetti for everyone. We got 16%. Champagne. Will Congress listen? Do our elected representatives have the civic courage to give these victims a platform, to demand accountability on national television? Or will they continue holding hearings about TikTok while American citizens rot in jail because of software failures? Priorities, people. Priorities. 120 million Americans deserve better than a government software monopoly that allegedly treats cybersecurity as optional and wrongful detention as inevitable. They deserve better than a company that detains people for 47 days and calls it a configuration issue. They deserve better than a vendor that exposes sealed records to Google and takes months to implement basic security controls. They deserve justice. They deserve accountability. They deserve answers. 21 years is long enough. The enforcement vacuum must end. The pattern must be confronted. Preferably yesterday, but today will do.
Detego Arcanis. Secrets revealed.